Alabama. For those that you are new, and for those of you who have been here, thank you for all of you for accepting the responsibility that you've taken to lead our students through their educational process. I am one of 5 attorneys in the University of Alabama's Office of Counsel. The lawyers for UA, UAB, and Birmingham and UA Huntsville are all one team of lawyers that report to the Chancellor's office. But we're assigned to campuses. So I've been working with the University of Alabama system for 28 years out of my 33 years of being a lawyer. So I've grown up at this institution and could not have I landed in it. I did not start out to be a higher education attorney. I was going to be a prosecutor, and I married one, so that excluded me from that possibility, or he would lose his job. But it truly is one of the best jobs in the world because I'm helping you all who are passionate about your fields make sure that the way you do your job keeps us out of legal trouble and keeps you out of legal trouble. Now, you all are a dual role, so when I train you today, I'm training you not only as an employee and as an agent and representative of the university, but you are also students. So a lot of what I'm talking about today applies to you to protect you, so that if you're experiencing any of the things that we're going to talk about today, you know who it is you need to go to get help. Or if you're in your GTA role as an employee, you know what responsibilities you have to not engage in some of the conduct. And you also will be told today about some of the things that you are mandatory reporters. If you learn about it, you're going to have to report to somebody at the institution. So I don't want you to get overwhelmed. I tend to be a very detail-oriented, not a big picture. Some of y'all might relate to that. But I want you to walk away with a couple main points. One is you're going to learn we have some policies, and your responsibility is to know we have the policy. I can't ask you to know everything about the policy, but I want you to spot the issue and know, oh wait, I remembered back in orientation, we have a policy that covers that. Number 2, I want you to know who it is that you contact at the university to get help. Again, you're not going to have to know everything. Just know we have a policy, who it is that I need to report this to. 3, I want you to know that you don't sit on that information, whether you're the victim or you're the employee, whatever the situation. Prompt reporting is critical. You've got to do it quickly because as time goes on, we lose the benefit of fresh minds and memories. If we have investigations that go on, we need it as promptly as possible so people don't forget things. And then 4th, I want you to walk away with this seminar, from this seminar knowing that if you bring forward any information, you are protected from retaliation. Whether it's a protection that's by statute, by federal or state law, or protection under our policy. And we're going to cover in our last slides the Code of Ethical Conduct at the university. And that basically is asking all of us as employees to report any kind of misbehavior, misconduct, ethical issues that are of concern. We are absolutely protecting all of us from retaliation if we bring that forward in good faith. Okay, so those are kind of the key points. Hopefully you found your materials by now. What I'd like to do is just tell you we're gonna cover a lot of policies. This is sort of a list of them, and I'm not gonna cover them all, but I wanna just point out the first handout is the one that was just handed to you, the important University of Alabama policies to know. For the first 3 pages, we're going to cover most of these policies today, but I've given you a different format and description, and this will be something that they've provided to you electronically, and it just helps you quickly find the policies we're going to talk about. There are 3, and they're the last 3 on this list, so you flip over to the 3rd page. There are 3 that I don't discuss in the slide, so I just want to very quickly highlight those. One is we have a dangerous weapons and firearm policy. I'm not sure if the police department or Charlie Dorr Dorsey. Later speakers this morning will talk about that, but we do have a written policy, and basically it's that students cannot have weapons on the campus. What you can do is you can check them into the UAPD and then check them out when you need them for off-campus purposes. Employees are permitted to have a weapon in their vehicle if it's properly licensed, but cannot take it into the workplace. Okay, so you can read more about that. Also, the next one is the alcohol and drug prevention. We have as all institutions do, a policy that says basically, you cannot have alcohol and drugs, illegal drugs on the campus, okay, unless you've been given permission for alcohol. So you'll have some events that you go through a permit process and you can have alcohol, but if you didn't go through that process, you can't have it on there. And then you go, why in the world are you talking about this? I actually handled a situation where this was actually an assistant professor trying to get tenure who thought it was okay since the policy said no alcohol on campus during regular business hours. So in that professor's mind, that was 8 to 5. That professor taught an evening class, so thought it was perfectly fine to bring in the cooler of beer and provide beverages for the students. Couldn't ask for a more caring and kind professor, but that was a huge violation of our policy. So I mention it because you can't have drugs and alcohol. You can't come to work impaired or under the influence. We have a new website. It's that's mentioned in this handout on drug and alcohol prevention that basically is trying to pull together all our policies and all of our the laws that apply in the state of Alabama and in the city of Tuscaloosa and the county, and also the resources that you can use to get help. Or for if you know people who have a drug or alcohol problem. We've got some fantastic programs that are on campus. We have addiction specialists now. And several years ago, I think we had a no tolerance policy that basically said, if you engaged in this behavior, you would lose your spot at the University of Alabama as a student. We've changed our philosophy over the years, realizing that some of these students are incredibly bright minds. Well, all of them are if you're here. But we were losing some great talent because we weren't providing another avenue. And so we've now invested a lot of resources to try and help our students who are dealing with addictions so that they can have some opportunities to succeed here. So that website will give you some information. And then finally, assumption of risk forms and insurance contact. If you all are doing things where you're taking students off campus or engaged in any kind of activity that would involve, more than the normal risk of going to a class. Let's say you are just going to take them on a field trip, to the Arboretum or whatever. We've got some assumption of risk forms that are on the risk management website. And basically, you've probably heard over the years, well, those release of liabilities don't really stand up in court. And that there is some truth to that, but in the state of Alabama, if there's a defense called assumption of risk. And so if you explain to your students what the risks are involved with that particular activity, and you give them a little bit of education about what those risks are and explain it to them, and they decide they're going to go to this activity anyways, knowing the risk, then in the state of Alabama, you have knowingly and voluntarily assumed that risk, and that is a total defense to any kind of negligence that may occur. So we've prepared, our risk management office has prepared some forms online, and so I wanted that you can use if you're engaged in any kind of outing like that where you need to take your students off campus. Okay. Let's move straight into the presentation, but before that, I wanted to just ask us to be civil and respectful of some of the topics that we're going to be talking about today and how they may evoke some emotion. So let me just kind of read the slide to you, okay? Some of the legal issues and examples that I'm going to discuss might be difficult to hear, particularly regarding child abuse or neglect, sexual assault, rape, dating, or domestic violence. And the words that appear on my slides unintentionally may provoke a negative reaction from someone who has gone through some of these experiences. I encourage you, if that is happening to you, for you to contact our Title IX office. Our Title IX coordinator is Beth Howard. You're going to hear that a lot today. Or contact one of our counselors at the Women and Gender Resource Center if you need support. And my materials, this handout, all your handouts, the UACT handouts, all contain contact information for those offices. I tend to discuss these legal issues in a very matter-of-fact way. My job is not a counselor, it's a legal counselor, and it's to train you in this session so that you're aware of information and resources that we have available on campus to report situations and to receive help. So as I discuss these matters, listen carefully and just be respectful of individuals who may have suffered from some of the misconduct I'm going to be discussing. So thank you for your civility and respect as we attempt to cover a lot of issues very quickly. All right, first thing I wanted to talk about before I get into the policies are what can happen if you don't follow the policies, if you breach them. Obviously, some of them could subject you to criminal prosecution, and our office cannot defend you in a criminal prosecution. So when we talk about the ethics violations or sexual assault, we can't, that would involve potential criminal prosecution, our office cannot come in and assist. Reputational damage. You can just read the media, and that can harm you personally for years to come. Loss of employment and GTA benefits. If you read your memorandum of appointment that you signed to get this job, there's some language in there that says basically the department chair and the dean, at any time if they feel like it's no longer in the best interest of the university, they can terminate your GTA. Now don't get upset with them, but I'm an at-will employee and you're an at-will employee. Now I've lasted 28 years here because I've tried to do the right thing. I've not always been right, and that's okay. We're not expecting you to always be right. We're asking you not to blatantly violate any university policy, and that's the purpose of this training session. But beware that you're just like I am. You're an at-will employee, and you could lose your job if you blatantly violate these policies. There are code of conduct sanctions. We're going to talk about those today, really with respect to students that may be violating, things in your classroom or associated with that. But it applies to you as well. So your GTA memorandum of appointment covers you in your employee status, but your code of student conduct covers you for your student status, okay? So you could, if you engaged in some of this behavior, be suspended or expelled or have some other penalties, and that would be through the Office of Student Conduct. We could also, if we violate these policies, we could be investigated by federal agencies out of Washington or state agencies if we're talking about our state ethics commission. Some of these are the Department of Education, the Office of Civil Rights, the Department of Justice, the Department of Education Office of Chief Privacy Officer. That's the office formerly known as the Family Policy Compliance Office, who regulates student privacy, and we're going to talk about that. And the privacy that you can expect and the obligations that you have to protect student information of your students. What could happen to us if they come and investigate? The very worst thing that could happen, that's never happened and will never happen because we're training you all, but we could lose our federal financial assistance, and that means all of our students who are here on loans, which is probably a good proportion of us, we would no longer be eligible to receive federal financial aid. So that's why it's very important that you all know about these policies. Then we could face civil litigation. We could be sued individually in some instances, or the institution could be sued. What I want to point out here is, good news for you is that our office has 5 attorneys, then we have other attorneys on other campuses, and we can step in and defend you, or we can hire outside counsel depending on the situation. We'll provide a defense to you in your employee capacity only if you did not blatantly violate one of these policies that we're talking about, or other university policies. So an example that we'll talk a little bit later about is our consensual relationship policy. We are not the love police. We are not saying you can't fall in love with that student that you just are passionate about and they're passionate about you. The problem with that is that you have some power over the student, and this applies to you as a student. We have a federal judge in Birmingham who fell in love with her law professor, and she's on the federal bench. It doesn't mean you can't fall in love. It just means at the University of Alabama, we say that while you're in that position of authority, you cannot be, if you're going to fall in love, you're going to have to report that to us, and then we're going to take steps to make sure there's no authority. A student would have to be removed from your class or you reassigned. So if you blatantly violated that, and you were sued because the student later came back and said, well, that GTA had the ability to change my grade, I needed the good grade, so it really wasn't as consensual as I led on, we would not defend you in that lawsuit. And that has actually happened before with a non-GTA, and we had to have that. It was actually a department chair, and that department chair had to defend herself in the lawsuit, and it was couple $100,000s out of her pocket to pay for that defense. So that's how serious that is about not blatantly violating policy. Other consequences are the cost and disruption of litigation. Obviously, it shuts us down as we're trying to prepare you for deposition and answer discovery questions, and you're trying to teach your class. And it's just very disruptive. And then obviously litigation could result in damages. So that's why I want you to pay attention today to avoid all these consequences. All right, let's get into the nuts and bolts of it. First of all, the university has an equal opportunity, non-discrimination, and affirmative action policy statement. And I've listed on the slide basically our non-discrimination, and it covers every protected category, and in addition, gender expression, gender identity. There's a split in the case law out there as to whether or not gender identity, gender expression, and sexual orientation are covered or not. In our circuit right now, some of these are not, some of them are. It really doesn't matter here at the University of Alabama because this is our policy. We will not discriminate on the basis of any of these protected statuses. We also, and I'm going to say it a million times today, we have an anti-retaliation. If you complain about behavior or you participate in an investigation or you just bring it to our attention, you cannot be retaliated against. There are federal laws that protect you, and our University of Alabama policy protects you. We have an affirmative action program. As a federal contractor, we're required to have one. What that means is that we have to reach out and do our very best to hire women, minorities, individuals with disabilities, and protected veterans. Those are the categories protected under that law. So I point that out because it's a fairly new, couple years old request that we ask you to self-identify if you are a protected veteran or an individual with a disability. We ask you to self-identify if you would so that we can meet federal reporting requirements and accurately report how many vets and individuals with disabilities. We've for years asked for demographic data about your gender and your race, ethnicity, but that's kind of a fairly new. Also, reasonable accommodation is covered in this policy, and we'll talk about that in the ADA section. But basically, we're required to provide reasonable accommodations to our students and employees who need those accommodations because of a disability. So that's sort of our general overall statement. You'll be mailed a copy of that in September. It'll come with a cover letter from the president, and it's also on our website. But again, you're one of the first groups to know about. We've always had it. We've just had a rewrite this summer, and I think it was May 31 when that policy went into effect. All right, the next handout I want you to pull out is the UACT. It's a one-pager. This is the one-page cheat sheet for you, okay? This is how I told you I wanted you to know the policy, but then I wanted you to know who to contact. This is the cheat sheet for who to contact for almost everything I'm going to talk about today. It's also online. It was recently revised as of yesterday, so you are the first group to get a copy of this. It will be handed out. We've had it again for a couple years, but it has been recently revised. One of the revisions is the reference to students who are pregnant who need accommodations. We make sure that you know on this cheat sheet that is the Title IX office that you go to. At the very beginning, it tells you that we're going to cover in this reporting channels for discrimination, harassment, sexual assault, or sexual violence. It then gives you contact information for the offices. And then the next chart is if you're a student, and both of you, you're in that dual role, so both charts are going to apply to you. If you're a student, and on the left column, if you want to file a complaint about discrimination of some type, and the alleged offender is, first row is an employee, second row a student, then you go to different people, okay? So at our institution, we have what's called designated harassment resource persons, and there's a website that will tell you who that would be. But basically, every college and every department at the university has a designated harassment resource person. So you can go to that person pretty much for most of these situations involving harassment, sexual assault, etc. If it's a gender-based conduct, we want you can choose to go to the designated harassment office, but they're going to pick up the phone and call the Title IX office. So you're going to avoid a step if you just contact the Title IX office. Okay? If you flip over on the back side, same chart, but now it's if you're an employee and you want to report, here are the reporting channels. Okay, it's pretty self-explanatory, and you just look over to the right column, which office I contact, you flip to the front page and get the details on that contact information. We're also going to talk about our hazing policy. We have reporting channels for that. They're listed there. Charlie Dorsey's going to be with you in an hour or two. He's going to talk about our threat assessment. This is the contact information for reporting alarming or threatening behavior. We also have a hotline. We told you that we want you to report any kind of unethical conduct that you see that might be occurring, but you might be nervous about giving your name associated with that. You can do an anonymous hotline report. Now that kind of limits us sometimes in our investigation if you're not willing to come forward, but at least it gets brought to our attention. So that tells you how to do that. And then finally, reporting channels for potential violations of our child protection policy, and we're going to talk about that in just a minute. There's also on the UACT website sexual assault bystander intervention videos that you could look at. Code of conduct violation, I think I've just covered all that, so we can go to the next slide. So now we're going to get into the nuts and bolts of each of the kinds of policies. One of them is our mandatory reporting requirements for abuse of a child. A few years ago, many of you have heard about the Penn State situation where Sandusky was ultimately sent to jail for sexually abusing minors on campus and off campus. As a result of that, just really changed a lot in higher education in colleges across the country. Well, our Alabama legislature also reacted to that, and prior to the Alabama legislature responding, University of Alabama went ahead and responded, and we came up with a child protection policy. And employees and volunteers who work with children who under this policy is defined as anyone 17 years of age and younger, then you have to have some training on this. So you should be assigned some mandatory child protection training, and I want you all to complete that if that's assigned to you. But basically it's going to tell you you are a mandatory reporter if you know of suspected child or abuse or neglect, and it occurs on our campus, on property owned or leased by UA, or while university personnel are participating in the activity. You can go through the training and get a little more clear definition of what is child abuse or neglect, but the main thing I want you to know is you're going to call 5454, the UAPD, if that occurs. There's a reporting form online to do that, and once you're trained in more detail on this, you'll have access to that. So who's got a report? I mentioned that we had a policy, but as of August of 2013, the Alabama legislature got involved and said not only is it mental health professionals and physicians who have to report child abuse and neglect, but anybody, even student employees who work at the universities, have to report suspected child abuse or neglect. This is one of those that the consequences is a criminal act. It would be a misdemeanor, 6 months imprisonment, or a fine of not more than $500. So y'all understand, if you know of child abuse or neglect, that occurs on our property or associated with our university activities, you are a mandatory reporter, and it is a crime for you, and you are charged criminally if you don't make that report. The good news is both the statute and our policy says you're not going to be retaliated for reporting, okay? Also, the statute says if someone tries to sue you civilly because you did the report, you're absolutely immune. That means I can file a motion to dismiss, cite this statute. We don't even have to take your deposition. You're out of the case because they cannot sue you, because that's how important of a public policy it is for us to get reports of child abuse and neglect. Okay? So that's really all I'm going to talk about with that, other than this one slide. This is new. We now have a registration process for activities and programs with youth participants. We've had efforts to try and, for groups on campus, faculty members, if you were bringing a group of minors to campus, we tried to work with you to make sure it was done properly. But now we've centralized that process. And so starting September 1, UA is requiring an online submission process for UA and third-party groups hosting camps, activities, or programs that involve youth participants. There's a lot more information on this website. Now, for those of you who are teaching students who are under the age of 18, that's excluded. You don't have to register because we already know about that program. These are those special things that are not for credit. The rule is you've got to start at least 8 weeks in advance in your planning process and go and contact this office and get the process rolling for you to have that camp. We've got to have background checks. People have to comply with the policies. I'm not going to try and train you on that, except for you to know if you're bringing in minors on campus, there is a process that you have to follow, or we're not going to allow you to do it. That's very important with our, when you hear from our threat assessment and your UAPD today, we need to know who's on our campus on any given day. And if we've got an active shooter on campus, we know about all of us, but we need to know about these guests who are on campus, especially our minor guests. So that's why we've got this process to help us be able to get to that information quickly. Okay, that's all I'm going to say about the child protection. Let's get into the Code of Student Conduct. We give you the website. I did not print that for your materials, but you can go on and look at it. It covers on-campus and off-campus violations. So if a student is engaged in sexual assault off-campus, we still have jurisdiction through this policy. The Code of Conduct basically says if you violate any of these policies, you have violated the Student Code of Conduct. So you've put your student status at risk. And this slide just has a lot of the policies that we're going to talk about. Next slide, just generally so you know how it works. Members of the university community can file complaints against any student for misconduct. Non-university members with direct knowledge and information about a violation can participate as witnesses. They may send some information to us, and that may generate an investigation. So if we learn about it, then one of our administrators might bring the complaint against a student. You have to prepare those complaints in writing and submit them to the Office of Student Conduct. And timeliness is very important. Our policy doesn't really have a statute of limitations, but what I mentioned earlier, prompt reporting matters. It matters with what we can do in an investigation. So our policy says we want it ASAP, but no later than 30 calendar days. Okay, but then if you failed to get it in within that 30 days, we're not going to say, well, we're not going to take action. We just, the faster you get the complaint made, the faster we can start working on it. All right, let's get into the kinds of things protected under the student code. One of them is if a student engages in harassment, threatening behavior, or bullying activity. So one of the kinds of harassment could be harassment of a non-sexual nature. It could be all the other protected categories that we're talking about. Unwelcome conduct directed at a person based on all of these protected statuses on the slides. It's got to be sufficiently severe, pervasive, or persistent so that it denies or limits the reasonable ability of a student to participate in a UA activity, opportunity, or resource. Any attempt to intentionally and repeatedly make contact with a person over their objection or to harass or alarm them, this is called stalking. That can get you in trouble, whether it's gender-based or not. It's a violation of the Code of Conduct. Also, if you invade the privacy of another person, you make, possess, store, share, distribute unauthorized videos, digital or photographic images of persons who have a reasonable expectation of privacy. Y'all may have heard many years ago about the student in, I think, in New Jersey, who his roommate filmed him having some private sexual activity with a partner. Posted that video on the internet, and that young man committed suicide because of the just devastating impact that this private moment was videoed and distributed without permission. That's a huge serious violation. Obviously, that individual who did that was charged with murder and convicted of that. Threatening behaviors directed to a person that causes reasonable apprehension of physical harm to the person or property, or bullying behaviors, teasing, social exclusion, threats, intimidation, stalking, physical violence, theft, sexual, religious, or racial harassment, public humiliation, destruction of property. There are a lot of other things in the Code of Conduct, a couple that I don't have on this slide that I want to mention that would be helpful to you. If a student is disrupting your classroom, there is a provision in the Code of Conduct that basically says if you're disrupting official university business, that's a Code of Conduct violation. I want you to feel confident that if somebody is disrupting your class, you call the Office of Student Conduct and you can file a complaint against that student. And a lot of times it's the student just needs some help, and we've got a bazillion resources to help them. But if you don't let the Office of Student Conduct know, we can't do anything about it. And if you're having that problem, chances are other faculty members are having that problem. Let's see what else I want to mention. The disruption, and also if you give a directive, or as a student, if somebody gives you a directive, a university official asks you to do something and you refuse to do it, and it's something that you're required to do, there's a provision in the Code of Conduct that says basically if you don't follow the directions of a university official that are appropriate, then you could also be subject to charges under the Code of Conduct. So I mentioned those two because of your role as an employee. You may need to rely on that. Because you may deal with some disruptive students in your class. So realize you've got a place to go. If you look on the UAC chart, it's going to tell you exactly who to go to. This is just another slide on that. I want to spend about the next 11 or so slides on sexual misconduct because that is a huge issue in higher education. Sexual misconduct under our policy, we have a separate policy just on sexual misconduct. It's a lengthy policy. It has a lot of appendices. One of the appendices that I don't think I mentioned on the slides is a list of accommodations. So it lists, I can't remember the appendix number, but it will tell you, okay, even if we don't find anybody responsible, and even if you don't want to bring a charge of sexual assault, but you're impacted emotionally, physically by it, we've got some help for you. And we don't want to discourage any student from ever going to get help at all. And you included. We have a list of a bunch of accommodations. It could be a housing accommodation. It could be an academic accommodation. It could be with your visa status. It could be with your financial aid. It could be we need to get a no contact order, restraining order. It may be a domestic violence situation. We've got a great university law, domestic violence clinic over in the law school. That's going to be a resource. All those things are listed in the sexual misconduct policy in that appendix entitled Accommodations and Interim Support. Okay, so this slide, getting back to this, defines what sexual misconduct is, and then it also says sexual exploitation. So examples of that are causing intoxication of another person for sexual purposes, electronically recording, photographing, or transmitting sexual sounds or images of other people. That occurs. It's amazing to me that students are doing that, and that is getting them in trouble. Allowing a third party to observe sexual acts, engaging in voyeurism, knowingly transmitting or a sexually transmitted disease, infection, or HIV to another individual. All those things constitute sexual misconduct under our policy. Sexual assault is any form of sexual contact without the consent of all parties involved. It could be sexual intercourse committed by physical force, coercion, threat, or intimidation. It could be attempted intercourse or sexual contact, and it could be any other kind of sexual misconduct which violates our state or federal laws, which are also in detail in the appendix to our sexual misconduct policy. So I just wanted to give you a broad overview of what that covers. Under our sexual misconduct policy, I mentioned it's got to be sexual assault without consent. Under Alabama criminal law, what is consent is a lot harder to, it's a lot harder for a victim to prove that he or she did not give consent. But here under our UA policy, consent means a clear willingness through your words or actions to participate in the sexual act. The fact that you consented on Monday night isn't consent for Tuesday night. The fact that you consented 2 hours earlier is not consent for future sexual acts. Consent can be withdrawn in clear communication, either through words or actions. Lack of resistance does not grant consent. You have not given consent if you are under the influence of alcohol or drugs. That does not mean that if you had a drink, you can't give consent. It means you're under the influence. That's a very difficult factual finding for our Title IX office to make, but I've listed in the slide here some of the things they're looking at. They're looking at the totality of the circumstances to determine if the inability to give consent is there. They're going to look at, was force used? Were the parties conscious or unconscious? Did they become sick because they were so intoxicated? Was their ability to communicate? Were they engaged in slurred speech? Was their walking impaired? Their coordination? Any other action indicative of the level of cognitive functioning? Those are the kinds of things that the Title IX office is looking at when they're determining whether or not consent was present. If you're unconscious, if you're asleep, if you're ill in a state of shock, you cannot give consent. If you are under the age of consent in Alabama, which is 16, so if you're 16 or younger, no matter how many times the person said, I want sex, you can't legally give consent. If you're mentally or physically impaired, you're not reasonably able to give consent. Now let's see if I can do this, or at least it's going to. I wanted to show you this video because I think it's important and it might be helpful to you if you have a student come to you, for you to share this with them to help them understand this concept.
If you're still struggling with consent, just imagine instead of initiating you're making them a cup of tea. You say, hey, would you like a cup of tea? And they go, oh my God, I would love a cup of tea, thank you. Then you know they want a cup of tea.
Sorry about that.
If you say, hey, would you like a cup of tea? And they're like, you know, I'm not really sure. Then you can make them a...
Hey, that played it twice.
I think we clicked it on twice and we had 2 of them going.
It's not a Mac. I'm used to a Mac. If you can relate.
And I can't do it all.
If you're still struggling with consent, just imagine instead of initiating sex, you're making them a cup of tea. You say, hey, would you like a cup of tea? And they go, oh my God, I would love a cup of tea, thank you. Then you know they want a cup of tea. If you say, hey, would you like a cup of tea? And they're like, you know, I'm not really sure. Then you can make them a cup of tea, or not, but be aware that they might not drink it. And if they don't drink it, then, and this is the important bit, don't make them drink it. Just because you made it doesn't mean you're entitled to watch them drink it. And if they say, no thank you, then don't make them tea at all. Just don't make them tea. Don't make them drink tea. Don't get annoyed at them for not wanting tea. They just don't want tea, okay? They might say, yes, please, that's kind of you. And then when the tea arrives, they actually don't want the tea at all. Sure, that's kind of annoying as you've gone to all the effort of making the tea, but they remain under no obligation to drink the tea. They did want tea, now they don't. Some people change their mind in the time it takes to boil the kettle, brew the tea, and add the milk. And it's okay for people to change their mind, and you are still not entitled to watch them drink it. And if they are unconscious, don't make them tea. Unconscious people don't want tea, and they can't answer the question, do you want tea? Because they're unconscious. Okay, maybe they were conscious when you asked them if they wanted tea, and they said yes, but in the time it took you to boil the kettle or brew the tea and add the milk, they are now unconscious. You should just put the tea down, make sure the unconscious person is safe, and this is the important part again, don't make them drink the tea. They said yes then, sure, but unconscious people don't want tea. If someone said yes to tea, started drinking it, and then passed out before they'd finished it, don't keep on pouring it down their throat. Take the tea away. Make sure they are safe, because unconscious people don't want tea. Trust me on this. If someone said yes to tea around your house last Saturday, that doesn't mean they want you to make them tea all the time. They don't want you to come around to their place unexpectedly and make them tea and force them to drink it, going, but you wanted tea last week, or to wake up to find you pouring tea down their throat going, but you wanted tea last night. If you can understand how completely ludicrous it is to force people to have tea when they don't want tea, and you are able to understand when people don't want tea, then how hard is it to understand when it comes to sex? Whether it's tea or sex, consent is everything. And on that note, I'm going to make myself a cup of tea.
Just heard a big wow, heard some giggles, but this is serious stuff. For someone who may have experienced it, it's very serious. The Department of Education, since 2011, has put a responsibility on higher education to try and change the culture of sexual assault on campus. And we've got to do a better job explaining. And this is an entertaining video, but I think it makes the point really well. So please make this video available to your friends, to others, your students. This is something they need to understand. If the criminal law doesn't define consent the same way, I want you to know this is the best description I know of what consent is or isn't under the University of Alabama policy. And if a student engages in conduct and offers tea when they shouldn't be offering tea, and forcing tea, that will get them in huge trouble, and we will go through the Title IX investigation. So hopefully that video was helpful to you. What do you do now if a student confides in you regarding an action, whether it's sexual assault or any of the other actions that are gender-based? We've got some FAQs that are coming out on our UACT website. They'll probably be up next week. They might be up today. They weren't up yesterday. But I know what's on there, so the next couple slides will tell you a little bit about what those FAQs, in a summary fashion. But the main key point, remember I said earlier, I want you to understand when you're a mandatory reporter, you're a mandatory reporter. A few years ago, we had a policy that said GTAs and faculty weren't, but we have changed our position on that a couple years ago. So you are a mandatory reporter. If in your capacity as a graduate teaching assistant, you learn of somebody who is complaining of any of these Title IX violations, then you are a mandatory reporter, and you must do promptly, not 30 days later, promptly, that day. I'm asking you that day, or if it's late at night, the next day during office hours, you're going to email or call the Title IX office. You're going to have students that say, I just want to tell you something confidential, and if it involves this, you're going to have to tell them, I can't be confidential. I'm a mandatory reporter. You're known as, under our policy, as a responsible reporting official. You have to tell them, look, if I can't keep it confidential, I have to let the Title IX office know. But I want you to know three things. One, I want you to know that you can call UAPD and you can make a criminal report. You don't have to, but you can, and I want you to know that. That's why that one-page UACT chart is critical. It's easy for you to remember. It's UACT. Okay, and then you just Google UACT on the UA website. If you can't find this handy-dandy chart, it's posted there. UACT, that's all you have to remember. They can contact our Women and Gender Resource Center. They don't have to tell you anything more. They can contact that office and have absolute, strictly confidential counseling and resources and help with those accommodations I talked about. They don't have to, the Title IX office will not know. This is important because if the Women and Gender Resource Center get the report, that's not knowledge to the university, so we don't have duties that kick in. If they go to you, we've got responsibilities, okay? So if they absolutely want it strictly confidential, we want to send them to the Women and Gender Resource Center. And then third, you want to encourage them to contact the Title IX office because they have the right to file a complaint. They don't have to, but you're going to have to report whatever was reported to you. And then what will happen is the Title IX office will send an email and try and reach out to that student and say, it's been brought to our attention that you may have information. We want you to know we're here to assist. They'll do that a couple times. They're never going to force a victim to come forward. That is their choice, except in one situation. If we know the name of the perpetrator, and this is number 2, number 3, then our Title IX coordinator has a legal responsibility under Title IX regulations to determine whether or not we need to move forward to protect the rest of us on campus. And if it's that kind of a situation, repeat offender, we may have to move forward without the victim, okay? But your job is to know you're a mandatory reporter and then contact the Title IX office immediately and let the student know about UAPD and the strictly confidential Women and Gender Resource Center and the Title IX office. Other information that you should know is that you are not required to report to the Title IX, and these are going to be on the FAQs, but you don't have to report things that some of y'all might be teaching English and you have them write an essay, and in their essay they describe a sexual assault. You are not a mandatory reporter under that situation. Or if you're having a class discussion and that comes out, you are not a mandatory reporter for that. Every year during a particular month, we have Sexual Awareness Month. You don't have to, if you're present at that event and you hear people sharing their testimony about what happened, those are not reportable, mandatory reportable. I already told you about Women and Gender Resource Center. We have other offices on campus that also are confidential. They're just not experts and totally focused on sexual assault and abuse and gender-related crimes and incidents against folks. These are other good places for resources, but if you want to get to the specialists, it's the Women and Gender Resource Center. You need to tell the student that reports to the Title IX office are kept as private as possible and shared only on a need-to-know basis. Now, sometimes the student may tell the Title IX office, hey, look, I'm reporting this, but I don't want you to tell the person I'm accusing that I made this complaint. And we have to honor that victim's wishes or that complainant's wishes unless, as I indicated, there's a threat to the rest of the campus society. But we still are going to have to try and do something about it. It may be that we have to do some training in some certain areas because the victim won't let us go directly to the individual involved. That's really not for you and I to figure out. That's for the Title IX office to figure out. Your duty is just to make that report. Other information you should know is reports of incidents off campus or a long time ago should still be reported. There are no time limits in our sexual misconduct policy. Our Title IX office decides if we have jurisdiction, and even if we don't, we still are going to offer accommodations to the persons that need it. And by the way, we offer services to both the accused and the accuser, okay? It's just, you got to go to the Title IX office, and in the appendix to the sexual misconduct policy, we have a list of all those resources that are available. You and I and other faculty members are not required to do an investigation. In fact, I don't want you to do that. I don't need to do that. We have an office who's trained and knows how to do that. There's some training that you will be assigned for faculty, staff, and graduate students called Haven. Once that assignment is made, I want you, it's an online training, I want you to make sure that you complete that training. The Office of Title IX is led by Beth Howard. Beth is a former employment lawyer out of Atlanta. We're very lucky to have her. She was an undergraduate student here, went off for law school and practiced law successfully in Atlanta and came back to help us meet our Title IX obligations. We have an office with several investigators now, and we're one of the few offices in the country that have just one person assigned just for accommodations. Their job is to coordinate with all the resources all over campus and kind of coordinate and make sure we don't drop the ball. They also coordinate with these designated harassment resource persons I mentioned earlier. So what do you do now? You're not involved, you don't get the complaint, but now you get an email out of the blue from either our Women and Gender Resource Office or our Title IX office. And you get an email and it says something like this: a student in your class had to miss class or a test because they were providing a statement to our office. You're not going to get any more details than that. It could be the respondent was making a statement, the complainant, or just a witness. But they need to be excused because we need them to participate in the process. So all I ask, the only thing you can do is if you want to verify, and that's a good thing to do, just contact the Title IX office and say, hey, I got this email, I just want to verify it came from your office. They say yes, then you just follow the instructions from which is usually saying, hey, I need you to excuse this absence or this test. If you need any help, call the Title IX office. But that is very likely to happen to someone in this group, okay? All right. Next, I want to talk about another aspect of Title IX, and that is protection for pregnant students and employees. The employees is really under Title VII. Not going to really talk a whole lot about that today, but on one of the revisions that was made to the UAC chart is making sure we said on there, because a lot of people didn't understand that sex discrimination also includes discrimination against women who are pregnant. So if you're a pregnant student, we have some FAQs for you, and if you are a professor or a GTA and you have a pregnant student in your class, then that's why we went ahead and printed the pregnant and parenting student FAQs, because you need to know what you can and cannot do. So Title IX protects students who are pregnant or have had a false pregnancy, termination of pregnancy, gone through childbirth, or they're recovering from any of those conditions. You can't exclude a pregnant student from a class or internship. You can't require them to withdraw from your class. Even if you're in a lab, and one of these labs that may have some dangerous chemicals, you can't say you can't participate in that. You call the Title IX office and they can help you work through some of your concerns that you might have. And we've worked through that in the past. You can't require a doctor's certificate of fitness to continue in an activity unless you require that of all the students that have medical conditions. So you just can't single out pregnant students. You cannot tolerate harassment. You do not need to harass or retaliate against any student who has asked for an accommodation. Possible accommodations, and this is the important part, and you really need to read this if you have a pregnant student in your class. Or if you become pregnant, these are things in your student capacity that apply to you. We may have to reschedule tests or exams. We have to excuse absences. Regardless of your typical makeup assignment policy, throw that out the door, because for pregnant students, Title IX kicks in, and a professor cannot reduce a pregnant student's grade because of attendance, or you can't reduce participation reports because she missed because of excused absences due to pregnancy-related conditions. They may have to be allowed to submit work after a deadline, and you've got to give them a reasonable opportunity to earn back credit that they missed. You have to provide alternatives to make up missed work. The makeup work does not have to be exactly the same as the missed work, but it needs to be reasonably equivalent. You can't make it twice as hard. It's got to be reasonably equivalent. The alternative might include, for a pregnant student, they might get the chance to just retake the whole semester, or give them additional time to complete the program and finish it at a later date. So a lot more details covered on those FAQs, but you're one of the first groups to get trained on this. The dean's got some training earlier this month, but we'll be talking to new faculty, and you'll be getting an email from either the provost or president later in probably in early September about all this, but you guys are one of the first to really get a little bit of explanation. Okay, so I'm going to have to start really picking up my pace here. We've covered code of conduct, child abuse and neglect, sexual misconduct. We're now going to talk about our overall harassment policy. So we're not just concerned about gender-based harassment, but harassment covers any protected status, okay? So if you're taking action or harassing someone because they're female or they're pregnant, that's gender-based, but now race, ethnicity, religion, disability, age, any of those protected categories, then that falls under our general harassment policy. We have a no tolerance of harassment based on protected status. It defines in that policy what that is. It requires prompt reporting. We've kind of covered that. This is important for you all. It requires supervisory personnel to educate, sensitize, prevent, and stop illegal harassment. So if you are the teacher, if the harassment is occurring in your class, you're our supervisory personnel. So you have a duty under this policy for your classroom to make sure that that kind of illegal harassment does not occur within your class. Our policy identifies the appropriate reporting policies, or reporting channels. Remember the UACT chart? That will tell you who to go to. So one pager for all of these things. There's a website, as I indicated earlier, that tells you who that person, and because it changes, people come and go, we just post it on a website rather than print it. We also, our policy assures confidentiality, kind of what we've talked about in the Title IX context. It's limited, only those who need to know. And then we promise no retaliation. As I mentioned, it covers all protected categories, the harassment policy does, so you just can't pick on people because of these characteristics, okay? The harm that's caused by the harassing conduct that will get you in trouble is if it unreasonably interferes with somebody's work or academic performance, or it creates a hostile or abusive work or learning environment. Or under Title IX, which is the gender-based, does the conduct interfere with or limit a student's ability to participate in or benefit from the services, activities, or opportunities offered by the school? That's kind of the legal test that we have. So what are the types of inappropriate harassment? Epithets, slurs, negative stereotypes, threatening, intimidating, or engaging in hostile acts, offensive jokes or pranks targeted at members of a protected group, placing on the walls or bulletin boards, or pretty much now electronically, any material that belittles, mocks, or shows hostility toward a person or group because of their protected category or characteristics. I wanted to give a word of caution about Facebook and other social media for GTAs. So as I mentioned earlier, you signed a memorandum of appointment, and you're like I am, we're an at-will employee. Remember, you can be held responsible for any pictures or text that you post that might, on your personal Facebook, that might demonstrate violations of our student code of conduct or the graduate school policy or university policy. So be careful. Particularly if you're directing students to your Facebook, because now, and we've actually had to terminate a GTA in the past who, instead of following our procedures, put all the course materials on the personal Facebook, directed them there, and then had a lot of inappropriate, unprofessional, and bordering on illegal activity going on the Facebook. So you don't want to be in that situation. So communications or pictures that could be deemed to violate the harassment policy or sexual misconduct or code of conduct, or they're otherwise inappropriate for the workplace, keep it off your Facebook or social media sites if you're teaching and you want students to go to your website. You can be disciplined under the code of conduct, and then, as I mentioned, you could lose your job. So be careful about that. We are not trying to step on academic freedom, free speech rights, but there's a balancing, and we're going to talk about that in a minute. I think I've already covered the confidentiality part in the Title IX discussion, but this slide just gives a little bit more detail, but for time's sake, we're going to move on. I have hopefully overemphasized the anti-retaliation policy, but I want to give a couple examples. What could retaliation be like? That last bullet says, anything that a reasonable employee or student would have found materially adverse, meaning it would have dissuaded a reasonable employee or student from making or supporting a charge of discrimination. Anything like that could be deemed retaliation. Some examples: lowering grades for students, refusing to give a recommendation, reassigning them when they're in group projects to another group, refusing to rehire a student employee. If you're an employee, losing your job, getting a poor reference, getting a negative evaluation, firing, those could be acts of retaliation, and we absolutely, as you know now, we just protect against that. Okay. Next policy I want to quickly discuss is our consensual relationship. I mentioned it earlier. We're not the love police, but if you've got authority over somebody else, somebody that you're in a welcome consensual relationship could come back later and say it wasn't consensual. So that's why we prohibit it, or you tell us about it so we can manage it. And that's basically what this slide is about. It tells you about our our consensual relationship policy. So that means if you're falling in love with your professor in your department, you need to report that to the department chair and make sure that we can manage it so that you're not under any kind of authority of that other professor. We can manage situations if we know about it. If we don't know about it, that's what could get you in trouble. And so you could lose your job not because there was actual harassment, because harassment is unwelcome conduct, but you could lose your job here because you violated our consensual relationship policy. Another aspect I want to talk about briefly is that academic freedom versus a hostile environment. Like, how far is too far? When do your free speech rights kick in? Well, the best example I can give is of a litigated case, Bunnell versus Macomb Community College. In here, this was a literature professor at the college who had been warned previously of his vulgar classroom speech. He taught English Lit, and he had the right to teach sexually explicit literature. That was part of his class material. That's fair game if it's part of your class material and it assists in learning. We're going to be teaching students ideas that are very offensive to their personal belief system, and that's what higher education is. It's a marketplace of ideas, and we all don't have to agree or morally agree, but we're a learning environment. We have to expose our students to ideas that are not comfortable for them, and that's perfectly legitimate if it's pedagogically sound and truly being taught for academic reasons. But in this particular case, this professor started discussing his literature and turned it personal, and he started talking about his own sexual escapades and asking students about their own sexual experiences. And then when the students in the class who were disgusted with it called him out on it, he basically started ostracizing them. So basically he gets in trouble. He gets in trouble, and he has to he files suit because he got in trouble and was disciplined, and the court upheld the discipline to the professor. And basically the bottom line is academic freedom cannot compromise a student's right to learn in a hostile free environment. It's got to be germane to the course content as measured by professional standards. So that case is built into, it's not that case, but that principle is built into our harassment policy. There's a provision in there that says speech or conduct of sexual or hostile nature exceeds that First Amendment protection if it creates this hostile learning environment and is reasonably regarded as non-professorial speech. You're advancing your own personal interests, not that of the academic process or legitimate objectives of the course. Or it lacks accepted pedagogical purpose. It's just not germane to the academic subject matter. Okay, I'm picking up pace here because I've got a time warning over here so that we leave time for questions. Hazing policy, I mentioned earlier on the UAC chart, if you know of somebody who's engaged in hazing, you have to report that. And that UAC chart tells you where. Hazing can be any action or inaction or communication that recklessly or intentionally harms or threatens the physical or mental health or safety of a person. And you're tying it to, if you want to be a member of this group, then you've got to engage in that in activity. That could be your band, that could be a club that you might be a part of, any kind of organizational structure. So realize you've got a mandatory reporting, and it's covered on the UAC chart. One other issue I want to bring up is the Clery compliance. If some of you are going to be student organization advisors, this statute applies to you. We are required, if you're a campus security authority and a student org advisor is, you have to report crimes that are reported to you to the UAPD, because every year the University of Alabama has to produce online and distribute to all a campus security report, and it has statistics for the campus on crime crimes on campus for the last 3 years. If we miss one of these because you all didn't tell us about it and you were a student org advisor or otherwise a campus security officer, we could get fined over $35,000 for missing one. So it's very important, if you are a campus security officer, that you report crimes to UAPD. So we have a lovely website. It's got a reporting form on there. We also give you the contact information. Chad Clark is our compliance coordinator for this, and be aware of that. Again, as a GTA, you are not a mandatory reporter. You're not a campus security authority, but unless you step into that role as an organization's advisor. All right, another switch in topics, guidelines for accommodating students' religious beliefs. You are required to put on your syllabus, and we've got it in the template that's available through the Office of Institutional Research and Assessment. If you're using that tool to help you with your syllabus, we've got some language in this that's already built into the syllabus. But basically, you are to put on your syllabus that students should notify you in writing or through email during the first 2 weeks of the semester of their intention to be absent from class for religious observance. Okay, so if we want to allow our students and our employees to not have to give up their freedom of religion and their exercise of religion because of their obligations as a student. But they have an obligation as a student to tell the faculty member that that's coming up, and then you will know what your religious holidays are. So then faculty should provide students who give the required notice the opportunity, just like we talked about pregnant students, you have to give them that opportunity to make up the work either in their original or alternative form without penalty, unless doing so would interfere unreasonably with the academic integrity of the course. If the student and the faculty member cannot agree on what that accommodation would look like, then the student can follow the procedure that we have for challenging grades, our academic grievance policy. All right, take a big breath. I'm going to take one. We're going to fly through students with disabilities. Basically, we have some FAQs, because I'm going to talk fast, but the FAQs are on pages 46 to 50 of your handout. And that's really going to cover everything I'm going to talk about real quick. But basically, the law is that students with disabilities who are otherwise qualified must receive reasonable accommodations and are protected from discrimination, harassment, and retaliation. You and I are not the trained people to decide whether someone has a disability. That is the Office of Disability Services does that. They ask for documentation from our students. They make the decision whether or not they're entitled to an accommodation. And when the Disability Services Office determines that they're entitled to one, they're going to provide a letter to the student, an accommodation letter. And in that letter, it's up to the student to bring that letter to you. And once they bring that letter to you, you are now obligated to provide the accommodation. Some students are going to wait mid-semester. They're going to try to take the test without any accommodation. That is their choice. But if they flunk the test and now they come to you with the letter and they want to redo, you are not required to do that. Why? Because they know from the get-go they have to ask for the accommodation. We're not going to allow you to retake something if you didn't give us notice. So tip for the day, document when you got the accommodation. That's not my slide, but document it so that there's never any question if they've already taken a test that they come back later and say, I didn't get an accommodation. Well, you didn't ask for it. All of this is built into the template in institutional research and assessment. It has that syllabus template. We've got some great language on there. It's also in my FAQs, some language you can put on your syllabus to let students know you need to come and provide that. You need to first go register. You don't need to provide an accommodation unless they give you that accommodation letter. Don't take their word for it unless it's an obvious disability. If they're in a wheelchair and they need an accommodation, you ask them to provide the accommodation, but don't withhold it for them until you get that letter. Those are obvious. But we pretty much want to make them go through the Disability Services office. So under the law, a student who's otherwise qualified has to is provided an accommodation, and they have to be able to meet the essential functions of being a student before we have to provide that accommodation. That means they have to comply with our academic standards. If they can't meet them, we don't have to accommodate that. They have to comply with essential attendance policies. They have to comply with our honor code. There's a case out there where somebody committed plagiarism and said, I did it because of my disability. We don't have to accommodate that kind of disability. We also don't have to accommodate, as you'll hear later this morning, if somebody presents a threat to the health or safety of others and it's caused by their disability, we don't have to accommodate that disability. The health or safety of others is more important, and so we don't have to provide that. What are some of the reasonable accommodations? Removing architectural barriers, and you can actually help us out if you know of one. If an elevator's broken or you see a curb cut filled with mud and a wheelchair couldn't get through it, we give you a number, a hotline to call, and what that does is in our work order system, it moves it to the top, and we're going to prioritize anything that needs to be fixed to help our students and employees with disabilities. You may have to provide note takers, tape lectures, interpreters. You may have to modify your policies and procedures, give some flexibility with your deadlines. All of that, though, will be outlined on your accommodation letters from Disability Services. So the main point is follow what they recommend. There's very few occasions where we can deny accommodations, so just realize it's very few and limited, and you're not the one that gets to decide whether we're going to deny it. These are the legal reasons, and I'll skip through that. So to save some time, what I'm going to do is the rest of these tips, these 9 or 10 tips, they're all spelled out in the FAQs, okay? I'm going to see. One thing I want to point out, because this was one of the lawsuits, I've dealt with 2 lawsuits involving GTAs, and the good news is both of them missed this training session. If they'd have just come to the training session, they would have known, okay? One of them was discussing the accommodation in front of the whole class. The student brought it up, and in front of the whole class, while everybody was present, argued with the student about the accommodation, said it was an unfair advantage, wasn't going to do it, like major ADA violations, but then the other one was the violation of FERPA. So don't discuss accommodations in front of the rest of the class. You don't get to know what the disability is. Do engage in dialogue with the student to make sure that you're going to provide that accommodation. Put that statement on the syllabus. Don't ignore them just because you disagree with them. We've got an appeal process, but while your appeal is pending, you're going to provide that accommodation. You could be sued individually if you don't do this the right way. Talk to ODS. They're there to help you. There are some ways that you can schedule tests online that the student can, so you may get an email so they can go to this center to help with accommodations. Let's say they need time and a half and you can't stay with them. They can go to the test scheduling center. It's not ODS's job, it's your job to make sure that that accommodation is provided. So you'll get some information about that, and that website has some tutorials about it. You don't want to ask a student about a dog in your class, except these 2 questions. Is the dog required because of a disability, or what work or task is the dog trained to perform? I don't have time to tell you why, but don't ask anything other than those 2 questions, okay? Also, if you have to have note takers, and again, this is your responsibility, not Disability Services, if that's one of the accommodations, then this information on this slide and in the FAQs will tell you how you can do that. Basically, you're setting up a box account, you're giving access to the student who needs the notes, and we're hiring one student in your class who's going to get $100 on their ACT card, and they're going to take notes, and the 2 won't know who each other are, okay? So follow that process, then you'll stay out of trouble. And then we want to make sure if you're using YouTube videos or any kind of electronic media, that that's accessible to all our students with disabilities, and we have offices on campus to help you make sure your stuff is accessible. I'll give you some contact information. Also, if you're an employee and you need an accommodation, the law is the same, the process is different. Instead of going to Disability Services office, you're going to go to our HR ADA coordinator, and there's a website and contact information for you to contact them. There'll be a process of getting documentation from your physician to support that you have a covered disability, and then we'll work with that office in Human Resources will work with the university in making sure you have an accommodation. All right, it's 10 after and I go till 10:25. Can I plow a little bit more, or should I take Q&As? I've always had this problem with time. If I can hit a little bit of the FERPA and then we'll skip. We're not going to have time for Code of Ethical Conduct. I've given you a 4-page handout in your materials on all the things you don't need to do to violate the Code of Ethics Conduct. But let's real quickly hit confidentiality of student records and we'll take some questions. So I'm going to skip over to 3 primary FERPA rights for students. So FERPA is the Family Educational Rights and Privacy Act. It is there to protect the privacy of student records. So now that you're an employee, you've got to protect the privacy of your students' records. A student has a right to review their records. They have a right to seek to amend their records. That doesn't mean they get to amend them, the right to seek it. That's usually a clerical mistake. We gave you a B when you deserved an A. All our records support an A. There's a process to follow. But the main thing we're going to talk about real quickly is a student has a right to limit disclosure of their education records to third parties. So what records are protected under FERPA? It's any record, file, document, and other material, including emails, and other computer databases and files that contain information directly related to a student, and we at the University of Alabama maintain it. Now, one exception to that is you may be maintaining records that directly relate to a student, but they're just for you. Your department chair doesn't have it, your boss doesn't have it, it's just your own personal note-taking. Those are called sole possession records, and a student wouldn't have a right to inspect those. If they fall under the record definition, the student has a right to inspect them. So beware, don't write emails about your students that you would not want your student to read, because they have a right to inspect them. But if it's just something you're keeping for yourself, you haven't shared with anyone else, they're not going to have the right to inspect them, so you don't have to worry about those. Big important point, oral conversations, personal conversations that you have with the student, or things that you observe that are never reduced to a record, that is not protected under HIPAA. That's different from when you go to the doctor. Everything is private under HIPAA. Okay, the conversations are private, everything in the record is private. That is not what FERPA is. FERPA only protects the record. Obviously, the fact that you're here in this classroom and I'm seeing you, there's nothing private about that. It's only what's reduced to a record, and that may help you as you think about situations. Can I tell someone, well, yeah, if it's not reduced to a record and it's something you observed, you can tell, okay? When can a record be disclosed? Anytime you get a written consent, or you get the consent through the MyBama portal where students can give consent to parents, then you can talk to them, and we'll talk to that in a second. Directory information is always fair game unless the student puts a hold on their record. If they don't, 99.9% of our students don't put a hold on their record, then we're going to be able to tell the media, the world, any of these elements, their name, etc. It's all on there, okay? These are things that wouldn't harm somebody. When else can it be disclosed? School officials. This is what, okay, we'll go to, okay. No. School officials can only, this is what happened with Virginia Tech several years ago with the active shooter. They thought under FERPA they couldn't share information with each other, but they ended up, some rules got changed after Virginia Tech. School officials who have a legitimate need to know, get to know. So if I call you and say, I'm working on a matter and I need to know what, I need to see your grade book, I'm a school official and I have a legitimate need to know to perform my job. So you can share it with me. You don't need written consent. You don't need to tell the student. And that's what Virginia Tech didn't understand, that offices on campuses could share information. However, once I get that information, it is inappropriate for me to leave it on my table at home and let someone else in my family see it. It is inappropriate for me to be putting it on Facebook or sending it through email without any other kind of protection. So you have to be careful if you receive that information and take steps to protect the privacy of it. Even though you got it legitimately, if you then go on and share it, or you're not careful in how it's maintained while you have it, then you can be violating FERPA. Real quickly, parents, this is going to come up. Parents in K through 12, they hold the privacy right. The student doesn't hold it, the parent does. But when the child comes to college, no matter what the age of the child is, when they come to college, the right transfers to the student. So get this, parents have no right to the student information. That doesn't mean that we can't share, because we have some exceptions, but they don't have a right to it. And so sometimes we're going to determine, even though we can, we're not going to give that to you for certain reasons. When are we going to disclose? When the student gives consent. And so on one of the handouts, and I think it's around page 53, I give you some information on how you can access. A student can go into the MyBama portal under their student tab, and they can go in and electronically say, I want to give permission to mom and dad to let them see my records. And the handout that I give you, because I don't have access to Banner, tells you how you can know in Banner. And you may not have access to Banner, but you can talk to the departmental secretary and make sure that if a parent calls you that their student has said through this MyBama process, I give permission to you. Otherwise, unless it's a personal observation, something you saw, if it's a record, you're not going to be able to talk to the parent about it without the student's consent. So you want to direct them to that link of where you want to help them. Hey, there's a way that your student can allow you to let me talk to you, and direct them through that process. The next one is, I don't want you collecting tax returns, but technically if they filed on a tax return, we could give them, never a right, we could decide. This one I don't think matters so much for you, it's judicial affairs. I got 5 minutes, so we're gonna cut this off. When may we disclose? Another big exception is any time there is a health or safety emergency. This is huge. I would rather defend you in a FERPA violation than in a suicide case, because we didn't pass on information to a parent that we needed to, okay? So if there is a health or safety emergency, the regulations, especially after Virginia Tech changed, and we can talk to parents if they can help us alleviate that health or safety emergency. The only thing that you have to remember is that you've got to write down the reason why. Now, you're going to have speakers this afternoon talk to you about our threat assessment and behavioral intervention team. Our UAPD, they're going to be here shortly. You need to be able to pass that information on, and don't worry about FERPA. We'll clean up any mess later. I don't want you to worry about it. And I want to go ahead and quit now and take questions, because we have about 2 or 3 minutes, or no Q&A.
We have time for
A couple.
2 questions. 2 questions.
And well, there may not be any. I flew through a lot. Remember the main points. Okay, we have one here. Someone going to take another mic?
Under the behavior policy,
Yes?
official or formal UA-sponsored organization.
For you to report, does it have to be an official UA-sponsored program? I always say this, don't split hairs here, report. You're never in trouble for reporting. Never. If you report in good faith, don't worry, oh, should I or shouldn't I, especially with the child protection, hazing, just don't, if you're concerned, report. You're always safe when you report. There's a question somewhere else?
Yeah, so going back to ODS.
Yes.
What if a student is, say, in a wheelchair, and I'm thinking of 10 floor where there's only one elevator, and what if that elevator is out of order and can't get up to a higher floor?
And so they're going to miss class?
Yeah.
You're going to have to help work with them. Well, one, you're going to call ODS ASAP, because it could be we're going to have to move your class permanently if we can't get the elevator working, but you definitely want to call ODS so ODS can quickly call and see if we can get the elevator fixed. But also, you're going to have to give some accommodations to that student by letting them miss work that they may have missed because they missed your class. If you have an office on the 2nd floor and a student needs to come see you and they're in a wheelchair, you've got to come down to the 1st floor if that's inaccessible. You've got to make yourself accessible. Great question. Got one in the back.
Yes, I was under the impression that under Alabama law, being any kind of teaching assistant or teacher at UA also make you a mandatory reporter for any off-campus violations, is that correct? So if you learn something outside of the purview of UA because of our position as a teaching assistant?
Yeah, this is going to be one of those, you hate lawyers, but it depends, okay? It depends on the facts. It depends on what kind of thing you're talking about. If it's sexual assault and it's a student on our campus who's been sexually assaulted, you are a mandatory reporter. If it's a child abuse or neglect, you're a mandatory reporter. So always err. I think it's better, I just can't say that there's an Alabama law that says that across the board. It depends on what the incident is, but it's always safe and safest to do the report.
This will be our last question.
Okay. You said that UAPD has jurisdiction. Does that include UAPD handling any possible criminal charges, or is that handled through another police department?
No, they are sworn law enforcement officers, so they can go down to the courthouse and meet with the magistrate judge and get arrests. And yes, our UAPD can do arrests. And they'll be here shortly, I think.
Yes. Thank you so much, Ms. Lindley, for...
I apologize.